Hello, everyone, and welcome to this debrief of Win This Together, a mediation advocacy webinar fireside chat series put together by CAMP and IDEX Legal. Now, we had a fantastic first episode where we talked about pitching mediation to a client, and we had 5 amazing speakers discussing the different strategies and ways that we can bring a client to the table. We had some fantastic interactions in the chat box and the Q&A section with some very interesting questions posed by the audience. Unfortunately, we didn't have the time to take up some of these questions, and therefore, today I have with you 2 special guests who will try and address some of these questions. Joining me from Bangalore is Ms. Shanta Chellappa, who is a senior mediator at CAMP and also a director at CAMP. And joining me from Bombay is Juin Nag, who is a mediator at CAMP. Thank you, Shanta ma'am and Juin, for joining us today.
Thank you.
Jonathan.
All right, let's get started. And so the goal is to try and answer these questions quickly and briefly and give you an understanding of, and try and clarify some of those doubts that the audience members had in their mind. The first question to Shanta ma'am, a very interesting question actually. And goes, is there a provision for pre-litigation mediation in civil cases which are to be filed in the High Court on the original side? If yes, then what is the minimum fees?
It's a very important question, Jonathan. I feel happy to answer this. As I know, pre-institution mediation in civil cases is introduced for commercial cases under the Commercial Courts Act. Any High Court having a original side jurisdiction will have a commercial division to file commercial cases. The court fee is payable as per the Court Fees and Suit Valuation Act of the respective states.
All right, thank you, Shanta ma'am.
Answer your.
Yeah, I think that pretty much answers that question in brief. And if anyone in the audience still has any doubts about this, do feel free to write into us. We can even get onto a free consultation call with you, especially lawyers who are concerned about this matter and who have actually a potential mediation on their hands. Write into us and we're happy to address this in detail. There is a nice summary of the first episode also, which will be published soon. Please check the description in the YouTube video for the link to that summary. Another very interesting question, and this one I think will be addressed by Juin. The question is, when there is court-directed mediation, is it necessary for parties only to choose from the impaneled mediators in court, say in the High Court or the Supreme Court? Or can parties engage a private mediator? Juin, you're on mute. No worries. Technical errors. Go ahead.
Interesting question, Jonathan. And I think it really depends on the judge who is referring the case for mediation. Typically, the court-directed mediation would go to the court-annexed mediation center, and an empaneled mediator will be assigned to that mediation. However, having said that, if in a particular case, the parties or the lawyers feel the need for having a specialized mediator or a mediation institute, like, for example, CAMP, I think it will be a good idea for that lawyer or the party to speak with the other side and make sure that there is a meeting of mind and request the judge to refer that matter to that mediator or to that mediation institute. I think if we apply this strategy, I think we will see success in the parties being able to appoint their choice of mediator or mediation institute.
All right, thank you. And I think the important thing is that both parties have to agree to take the mediation to a private mediator. And as long as that's there, I think it's fine. Another very interesting question, and this one is out to Shanta. Do we need to get a mediation settlement enforced to court?
It's a very practical question, Jonathan. It is not necessary when the parties honor the terms of the settlement agreement. But normally what happens in court-annexed mediation, where the matter is referred to a court-annexed mediation center, or to a private mediation organization like CAMP, or to a private mediator, the mediation settlement goes back to the court and the court passes a judgment or order, which is enforceable by way of execution. If the agreement is arrived in a pre-litigation mediation and one of the parties fail to honor the terms, the other party has to file a suit for specific performance of the terms of the agreement. The agreement is enforceable, but it is not executable. So you have to file you cannot file an execution to enforce the terms. The party has to get a judgment or an order from the court. But the one more way which we can address this is the settlement agreement can be converted into a conciliators award under section 73 and 74 of the Arbitration and Conciliation Act. This award is equal to an arbitrator's award on agreed terms under section 30 of the Arbitration and Conciliation Act. So it will have you can directly execute the award in the court and the parties can get their relief, whatever they have sought for. They need not have to go to the court to seek for us. So they need not have to file a suit for specific performance.
Thank you, Shanta. I think that's very crisp and clear answer to the fact that, yes, there is no excuse to say that a mediation settlement cannot be enforced and it's not binding and it has no credibility and no value. These are excuses. So there are ways that are, with a new proposed mediation law, this will get a bit more clearer. But as we stand today, there are enough of ways to take care of, a mediation settlement agreement that is being drafted with goodwill, and it can be enforced for sure. Thank you so much. There's another very interesting question about, how to decide whether a case is suitable for mediation or not. Now, with regards to this, I think I'll take this one up. At CAMP, we actually have developed an index, or what you would call a criteria of sorts, where we put together or put across around 20 questions to the lawyers and the clients who are coming to us, and we make them answer these questions. And these depend on a lot of factors, external factors, timelines, past history of collaboration, and a lot of other things that we kind of make them reflect upon. And upon that reflection, upon them having gone through this criteria, we then try and decide whether this case is suitable for mediation or not. So happy to take any lawyer out there who's not quite sure whether his or her case is suitable for mediation. Happy to take you to this exercise. It won't take you more than 20 to 25 minutes. And at the end of that, you can decide whether you would like to mediate this case or not. So let's not assume by ourselves whether this case is mediatable or not. I think as an institute, CAMP is ready to help lawyers to find out and analyze whether a particular case is suitable for mediation or not. So reach out to us for any more information on this regard. Next question to you, Juin, a very interesting question once again. How to handle a lawyer who's not in favor to settle the matter and his client doesn't understand that going for litigation is not beneficial. So you as a lawyer, you are convinced of mediation, your client is convinced. And on the other side, your counterpart is just being, unable to convince the other side. So how do you handle something like that?
Well, that's a very interesting question, Jonathan. And I think where we are in terms of the mediation journey today in India, I'm sure any mediation-ready lawyer who is, suggesting mediation as a strategic step in their dispute resolution to its clients will be probably facing this question, hopefully less often than not. So therefore, I think we must look at this question very, very seriously. And I think when I look at this question, I think what we can do is probably, as a private mediation center, we provide reach out services. What does it mean by these reach out services is that we strategize with this lawyer and their client when they're trying to reach out to the other party as to whether there are other people or influencers who could reach out to the other side and show them or tell them about the value in mediation and see if the other side or the other party could be brought to the mediation table. We are hoping that that works and the strategy works to get the other side to the mediation table. If not, Then as a private mediation center at CAMP, we also offer opt-out services. What does that mean? That as senior mediators of CAMP, Shanta, Rukmani, Laila could sit with the other side and tell them about their experience, the value of mediation, and why mediation makes sense. This is free of cost, and parties could come in and hear about the value of mediation, because I'm guessing in this case the other side does not have that exposure to mediation or a good mediation experience. And if they see the value in mediation, then they go ahead with the mediation. Needless to say, mediation is a completely voluntary process, so both parties will have to agree and come to the mediation table. However, in our experience, as Shanta would tell you, we have seen that these opt-out services are very useful, and oftentimes parties see the value in the mediation and come to the mediation table. So in one line, if I could say, then my suggestion to that legal counsel who's struggling to get the other side to the mediation table would be that reach out to us. Let's strategize as to how to get the other side to the mediation table. Thank you.
Thanks, Joanna. I see a lot of value in that, reaching out to the other side from a neutral perspective, and how we can kind of, help a mediation institute can kind of help coach one side to reach out to the other side in a way. And of course, this is very, very interesting times for mediation in India. And if you have a dispute where you are convinced of, you got to try and bring in all resources possible to try and convince the other side to also come to the table. So as Juin says, do reach out to us if at all you think you need assistance on this. Final question, and this one to Shanta. Very, very interesting question. Could you throw light on the obligatory nature of mediation and party autonomy? And this, I think, is with regards to the Consumer Protection Act, which talks about sending a dispute to mediation if the presiding officer feels it's suitable, right? So the person in the audience says that, is it necessary, or how does this point of referring it to mediation affect party autonomy and the choice of choosing your own mode of dispute resolution? Does it affect it? And what is your response to that?
First of all, I don't think it is made obligatory under law to refer all the matters to mediation. There are cases which are unsuitable for mediation. The court has to apply its mind. The court has to see whether there is an element of settlement which is acceptable to both the parties. Then the court checks with the parties whether they would like to go for arbitration or conciliation. If they are not interested to use arbitration or conciliation, and where the matter is simple, the matter is referred to Lok Adalat, and where the complicated matters are referred to mediation. But only the mediation, the referral is mandatory under Order 10 Rule 1A of the CPC. These amendments came in 1999 and came into effect from 2002. Since then, it has become a routine to refer mediation in court to court-annexed centers and by the court. Secondly, under Consumer Act, so this is something which is equivalent to Italian opt-out model, which Join has referred to. The parties are only requested to go and attend a session, and after that, the participation is voluntary. If they want to continue with the process, they can continue. Otherwise, they can always go back to the court to continue with their litigation. So it doesn't make it obligatory on the part of the parties to attend the entire mediation process. So the entire process is party-centered and self-determination. So there cannot be an obligation there. And you asked about Consumer Protection Act. Under Section 37 of Consumer Protection Acts also, a reference to mediation at the first hearing or after the admission or during the process of the case, the consumer court can see if there is an element of settlement which is acceptable to both the parties, can request the parties to give consent for mediation. Once the consent is received, then the matter is referred for mediation. So there is no obligatory on the part of the court to refer all the matters. Actually, under the rules of 2020 Consumer Protection, under the Consumer Protection Act, there are certain matters which have been prescribed which are not suitable for mediation. Such matters cannot be referred to mediation. I hope that it clears the point which you have made, Jonathan. Thank you.
Clear and crisp, Shanta and ma'am. And of course, we could have given you much more detailed answer to this, but do reach out to us once again if you have any more clarifications with regards to this question. I think the mandatory model really helps create a lot of awareness more than anything else. And participation and actually settling is not absolutely not mandatory, and you cannot be forced to do anything of that sort. Mediation remains a voluntary process through and through. Thank you so much, Shanta and Juin, for joining us today for this debrief. Thank you, everyone. And please keep up to date with the rest of the episodes coming up soon. The next episode is on August 26th, and we hope to see you all there. We're going to talk about how does a lawyer prepare for mediation. Thank you so much.
Thank you, Jonathan. Thank you.